Hi, my name's Gavin and I'm the Senior Managing Solicitor of Emerson Family Law. Today I'd like to talk to you about the top 6 myths regarding domestic and family violence law in Queensland. Myth 1. Domestic and family violence is just physical violence. Domestic violence under Queensland law can also include emotional or psychological abuse. They include any of the following: repeatedly contacting a person by telephone, SMS message, email or social networking site without the person's consent, following a person when the person is out in public, including by vehicle or on foot, remaining outside a person's residence or place of work, repeated derogatory taunts, including racial taunts, threatening to withhold a person's medication, threatening to disclose a person's sexual orientation to the person's friends, and preventing a person from making or keeping connections with the person's family, friends or culture, including cultural or spiritual ceremonies or practices, or preventing the person from expressing the person's cultural identity. Domestic violence can also include economic abuse, such as coercing a person to relinquish control over assets and income, removing or keeping a person's property without the person's consent or threatening to do so, preventing a person from seeking or keeping employment, coercing a person to claim social security payments, and coercing a person to sign any legal document for the establishment or operation of a business, a contract of guarantee, a contract for the purchase of goods or services, or a contract for the provision of finance, a loan or credit. It's interesting to note that the numerous examples of domestic and family violence which I've just mentioned are actual examples as currently contained in the legislation in Queensland. Myth 2. I was never married to my ex, so I can't apply for a DVO. That's incorrect. As long as a relevant relationship exists between the parties, an application for a DVO can be filed in court. Under Queensland law, a relevant relationship is defined as 1. An intimate personal relationship, being a spousal relationship, including married or de facto, whether heterosexual or homosexual, an engagement relationship, including a betrothal under cultural or religious tradition, or a couple relationship between two persons if the persons have or had a relationship as a couple, but not necessarily as a de facto couple. Can also include a family relationship, being a relationship between two persons if one of them is or was the relative of the other person who is ordinarily understood to be or to have been connected to the person by blood or marriage. So for example, can include a person's spouse, stepchild, parent, step-parent, sibling, grandparent, aunt, nephew, half-brother, mother-in-law, or aunt-in-law. It can also include an informal care relationship, being a relationship between two persons if one of them is or was dependent on the other person, that is the carer, for help in an activity of daily living, such as dressing or other personal grooming of a person, preparing a person's meals or helping a person with eating meals, shopping for a person's groceries, and telephoning a specialist to make a medical appointment for a person. Myth 3. I must prove that domestic and family violence is likely to occur in the future before a court will make a DVO. This used to be a compulsory requirement, which from an evidentiary perspective is very hard to prove. As long as the following compulsory requirements are met: firstly, a relevant relationship exists between the aggrieved and the respondent. Secondly, the respondent has committed domestic violence against the aggrieved. And thirdly, the DVO is necessary or desirable to protect the aggrieved from domestic violence. A court may make a DVO. Myth 4. An undertaking is the same thing as a DVO. Firstly, what is an undertaking? Typically, it's a written and signed document entered into by the respondent by consent on a without admissions basis. That is, even though the respondent disputes some or all of the allegations made in a protection order application, the respondent immediately undertakes to be of good behaviour and not commit an act of domestic violence towards the aggrieved. This is considered the quickest and easiest solution when faced with a protection order application, especially in circumstances where the respondent does not wish to defend the action and agrees to enter into this document, the undertaking, without affecting his or her livelihood or otherwise impact significantly their life. However, it is very important to remember that an undertaking is neither legally binding nor enforceable, especially if the respondent breaches his or her undertaking. Conversely, a DVO approved and sealed by the court is both legally binding and enforceable by the court and the police. So if you want something legally binding and enforceable, a DVO is always the preferred option. Myth 5. A DVO is a criminal offence. It's not. This means that if a DVO is made against a person, it does not automatically result in a criminal record. This is because a DVO is considered a civil law order between two people. However, it is important to remember that a breach of a DVO is a criminal offence and may lead to a criminal record. So in those circumstances, it is always recommended to speak to a lawyer for further advice. Myth 6. A DVO will not affect my ability to work. That's not necessarily true. A DVO can affect employment prospects in at least two ways. Firstly, if you apply for a position in child-related employment, a prospective employer must do a working with children check. This check will show up any final DVO which is made for the protection of a child. This means that if you are planning a career in any work that involves contact with children, a DVO can potentially limit your career prospects. In some cases, even those who work with children in a voluntary capacity need to undergo a working with children check. And secondly, a person who has a DVO against them cannot have a firearms licence whilst the DVO is in force. So this means that if you have a DVO against you, your employment prospects in the security industry may be affected. Equally, if you work on a farm and you need a firearm to carry out your work, a DVO will ultimately prevent you from carrying out that work. So if you'd like to find out more, please visit our website www.emfl.com.au or give us a call on 07 3211 4920 to arrange an initial meeting today. Thank you.